just woken up from New Year's Eve. I thought it was about time I had a look at what's been happening and what is to happen in lawland. For the avoidance of any doubt, I'm Stephen Gold, and I wrote The Return of Breaking Law. There's plenty of cat poo about. Are you fed up with finding the poo from your neighbour's cats in your back garden?
And front garden. And on the patio.
Well, it's sometimes thought that cats can poo with impunity wherever and whenever they choose, as they have what's known as a common law right to roam. Well, that's what Caerphilly County Borough Council thought. Local man Richard Williamson had had enough of his neighbour's two cats fouling his front garden, so he did the right thing. He complained to the council that what was happening amounted to a statutory nuisance and that the council should put a stop to it under the 1990 Environmental Protection Act. The Act covers all manner of objectionable activities, from noise, smoke and smells coming from premises and otherwise, which prejudice health or are likely to do so or amount to a nuisance.
But not cat poo, surely.
Oh yes, an accumulation or deposit which is prejudicial to health or nuisance is called. And our Mr. Williamson maintained to the council that that could include an accumulation or deposit of cat poo. If the council agreed, it could have sent the cat owner an abatement notice requiring the pooing to cease, at least in Mr. Williamson's garden. And if that didn't do the trick, the cat's owner could have been prosecuted in the magistrates' court and fined. In a really serious case, councils can apply to the High Court for an injunction against the person responsible for the statutory nuisance.
So what did Caerphilly Council say to Mr. Williamson?
Well, they said the Act did not apply to the neighbour's cats.
And what did Mr. Williamson say?
Oh, I won't go there. Only joking. It's not what he said, it's what he did. He took on the council and he applied to the High Court for a judicial review of its decision, arguing his case in person. And recently, he won. The High Court ruled that the council had approached the complaint in the wrong way, and instead of focusing on whether the poo constituted a deposit prejudicial to health or nuisance, had concentrated on the cat's rights to roam and how their owner had looked after them. Well, the council was ordered to reconsider the complaint. Take this scenario. You live in a block of flats and you're stuck with having to pay a service charge. As part of the service charge, you're being asked to pay a fortune to repair a defect in the block, perhaps structural, but the defect originated before you purchased the flat. Well, having banged hard on the kitchen table and then ripped up the service charge demand with two injured fingers, what do? Check, through a solicitor, if you can afford one, whether the wording of your lease covers the work in question. If it doesn't, you're not liable to pay. And so it was in a major case that's recently been decided by the Court of Appeal. Now, that case involved pre-existing structural defects, and the lease wording, you'll find an extract in this video's fact sheet. That wording required payment for safety works to two buildings and any other expenses reasonably and properly incurred by the landlord in connection with the building. And the works in question in this case were for the building's safety. Safety in the wording took its place, though, in the middle of a list which also included management, maintenance, amenity and administration. And this suggested, held the Court of Appeal, that the wording was concerned with relatively routine matters arising in the day-to-day management and administration of the building, and not with matters as fundamental as a pre-existing structural defect exposing the building to the risk of collapse.
So why a legal argument? The words sound pretty clear to me.
Well, words in legal documents are not always interpreted in the way at first blush you might have expected. And that meant that each of 32 people holding leases in the blocks were not legally responsible for between £70,000 and £95,000, which their landlord, Tower Hamlets Borough Council in London, had demanded from them. Incidentally, this dispute originally went to the first-tier tribunal in what's called the property chamber. That's the place for a leaseholder to go when making a service charge challenge if the landlord or managing agents will not back down. The Royal Institution of Chartered Surveyors. Sounds posh, eh? And it is a bit. Call it the RICS. It tells its members about the professional standards of conduct it expects from them, and they've taken to doing this through a code which has statutory backing. Well, this code has a heavy concentration on residential service charges and with advice on various matters for landlords, leaseholders and agents. If you're in dispute with your landlord or managing agents, particularly on service charges, the code could well back you on an argument that the landlord or agents have acted wrongly and against the practice they should have adopted. A judge hearing a landlord and tenant dispute could take the code into account in deciding the dispute. Well, the fourth edition of this code has just been published and is effective as from the 6th of April 2026. For any dispute which arose before then, the code's third edition should be pored over. Well, they say there's no such thing as a free lunch, but there is such a thing as a free RICS code. Yes, you can download the code for Nout at the address coming up, and you'll also find that address in my fact sheet.
Free fact sheet?
Of course. The right to paternity leave has depended on Dad having been in a job for at least 26 continuous weeks. For parental leave, it's been 1 year. These qualifying periods are scrapped as from the 6th of April 2026. The right to both paternity and parental leave will arise on day one of the job. Boss, have I got some news for you? The paternity leave change won't apply where the child was born before the 6th of April. Another change, paternity leave may be taken after shared parental leave.
Anything else happening on the 6th of April?
Well, apart from you preparing a tax return for the new financial year, you mean?
No comment.
Well, as it happens, there is. On the employment front, the amount of compensation available from employment tribunals enjoys an inflationary increase where a worker is axed or whatever else occurs that generates a right to compensation on or after the 6th of April 2026. The compensation limits are up by 4.5%. So, for example, that will push up the compensatory award for unfair dismissal to £123,543, with a basic award on top depending on length of service. And the amount treated as 1 week's pay, the figures used to calculate that basic award, and also the amount of redundancy pay, that's up to £751. What would you do if you were being sued for damages by somebody who claimed that in an accident you'd caused, they were seriously injured and could no longer walk without a frame, and you were convinced that all they had suffered was a scratch to the right buttock? You would get them secretly filmed, jumping over rooftops, wouldn't you? Insurers who face the prospect of meeting a heavy damages claim spy on claimants they say are exaggerating their condition all the time.
But isn't that an invasion of their privacy? Will the court look at the secret film footage?
Well, that, as they say, is the question, and it's a question that's just been answered in a claim before the High Court. This claim was by a lady who was acknowledged to have slipped and fallen heavily on the wet toilet floor of a cruise ship. She alleged a high level of disability had resulted, mainly the development of a functional neurological disorder. She was after damages topping £10 million. The defendant's insurers said her claim was worth no more than £25,000. Well, the insurers set about having her secretly filmed from the highway outside her home. It said that she was seen in her kitchen walking around normally. Well, nothing sensational about that, except this mobility was at odds with her alleged account to a pain management expert that around this time she couldn't walk and she needed a wheelchair.
So the insurers pretty quickly sent a copy of this surveillance film to the lady's solicitors and said, "Gotcha."
Well, no, they sat on it for 9.5 months before disclosing it, and they made that disclosure just 3.5 months before the lady's 5-day damages trial was due to start. If the film was to be allowed in by the judge, then the listing of that trial would be lost. It would have to go back into the queue for another hearing.
I can't stand the tension. What happened?
Patience, please. Well, the judge had a discretion when the insurers asked for permission to rely on the film as to what the judge should do. The main issue was whether the claimant had been ambushed by the material. It wasn't as if she'd first been told about it when giving evidence at the start of the trial. She'd been able to see it at her leisure, and her team of medical experts would have had an opportunity of viewing it and giving their opinion about it. It wasn't suggested there'd been any trespass on her property in the course of filming either. True that the insurers had sat on the film for some time, but they had been entitled to assess their evidence once the claimant gave her up-to-date account of her condition before they disclosed the film. The judge decided that the court would look at the film and the claimant could be cross-examined about it when the case ultimately, again, comes on for trial. I should make it clear, however, that the court has yet to decide on the authenticity of the film and the evidence of those who shot it. And just in case you're making a claim for personal injuries after an accident, worth remembering this: you never know who's watching. Not long to go. The biggest shake-up of the law on private residential lettings in England is imminent, with the first phase of last year's Renters' Rights Act coming into force next month on the 1st of May 2026. My last video for December looked at what the new law will mean for landlords and tenants. That video can still be accessed. Just a reminder for landlords, any tenancy granted on or after the 1st of May will be governed by the new law, which includes the abolition of so-called no-fault evictions by giving the tenant at least 2 months' notice to leave and following up with a county court claim for possession if necessary, even though the tenant's done no wrong. Any notice given before 1st of May 2026 will still be valid, but of no effect unless the county court claim is started by the 31st of July 2026. When a new tenancy is granted on or after the 1st of May, the landlord must give written notification to the tenant of various terms of the letting. Those terms have been set out in regulations, and failure to comply will be an offence for which a penalty against the landlord of up to £7,000 will be available. The landlord can include this statement in the tenancy agreement itself rather than in a separate document if preferred. Landlords under existing agreements, those made before the 1st of May that is, don't entirely escape. If the agreement was verbal, nothing in writing, this written information must be provided to the tenant before the 1st of June 2026. And landlords of existing tenancies in the private sector must generally give their tenants something different, an information sheet available online about their new rights, and that's been drawn up by the government, and they must do so by the 1st of June. Again, an offence for the landlord who fails to do that. Well, you can get hold of the information sheet at this web address.
The free Law Watch fact sheet that Stephen mentioned is available from www.breakinglaw.co.uk. Stephen Gold is the author of The Return of Breaking Law.